Inchoate offenses. There's 3 inchoate offenses: solicitation, conspiracy, and attempt. Under conspiracy, we're going to talk about vicarious liability. So under inchoate offenses, discuss solicitation, conspiracy, vicarious liability, and attempt. Solicitation is simply asking someone to commit a crime with a specific intent that they do it. Conspiracy. At common law, conspiracy was an agreement between 2 or more persons to commit a crime. Modernly, an overt act is required in furtherance of the crime. The Model Penal Code has the unilateral rule versus common law, which requires 2 guilty minds. Vicarious liability. If you are members to a conspiracy, you are liable for all foreseeable crimes committed by your co-conspirators, even if you don't participate in those crimes. Attempt. The defendant is guilty of criminal intent when the specific intent to bring out a result which is criminally prohibited, he comes substantially or dangerously close to accomplishing that result. The defenses to inchoate offenses, there's 3 of them: impossibility, factual impossibility, legal impossibility, withdrawal, and merger. The 3 defenses to inchoate offenses are impossibility, withdrawal, and merger. Impossibility. Factual impossibility. The defendant intends that the criminal act but cannot accomplish because of facts unknown to him. You steal from an empty pocket. Legal impossibility. It is impossible to complete the crime because what the defendant was trying to do is not illegal. Withdrawal. At common law, withdrawal is no defense. For solicitation, complete when the defendant asks someone to commit the crime. For conspiracy, complete once there was an agreement between 2 guilty minds to commit the unlawful act. Model Penal Code allows withdrawal only if the defendant withdraws voluntarily and completely renounces the conspiracy due to change of heart, not due to fear of getting caught. Merger. At common law, merger only worked in 2 contexts: lesser included offenses. A lesser included offense will merge with the greater offense because it is a crime that includes all elements of a greater crime. Example: larceny is a lesser included offense of robbery. Larceny is not a lesser included offense to burglary because not all burglaries include a larceny. Example: rape. Solicitation and attempt merge with each other, but conspiracy does not. Capacity defenses. There's 3 capacity defenses, and they are insanity, intoxication, and infancy. Insanity is if the defendant actually has a mental disease. Then there's a variety of possible tests that can be used to determine whether or not the defendant is insane. Intoxication. You have involuntary intoxication, not that you accidentally drank too much, but that you were given an intoxicating substance against your will, or you didn't know that the intoxicating substance was given to you. Voluntary intoxication may be a defense to specific intent crimes if the intoxication negates the specific intent. Infancy. Common law, under 7 years old and capable of being prosecuted. Under 14 years old, there's a rebuttable presumption, and 14 and up, you can be prosecuted for anything. Modernly, infancy is not considered a defense because of our family court system that we have in place. Insanity. List the 3 possible tests and define. The McNaughton test, the irresistible impulse test, and the Model Penal Code test. The McNaughton test, you ask, did he know it was wrong? If the defendant did not know that their act was wrong, nor understand the nature and quality of their act because of his mental disease or defect, he will not be guilty by reason of insanity. Again, McNaughton test. If the defendant did not know that their act was wrong, nor understand the nature and quality of their act because of his mental disease or defect, he will not be guilty by reason of insanity. Irresistible impulse test asks, could he control himself? Whether the defendant was either unable to control his actions or unable to conform his conduct to the law. Whether the defendant was unable to control his actions or unable to conform his conduct to the law. Model Penal Code. It's also known as a substantial capacity test. So either the MPC test or the substantial capacity test asks, could he have been aware of the substantial capacity to conform himself to the requirements of law? If the defendant lacked the substantial capacity to either appreciate the criminality of his actions or conform his conduct to the law. Limitations on deadly force. You have the aggressor rule and the retreat rule. Deadly force, remember, can be used if it is reasonably needed to protect against immediate deadly force against himself. Must be of equal force. So the aggressor rule is the defendant can't use deadly force when started the fight unless the defendant backed out from the fight or the victim escalated the force from a non-deadly to a deadly force. Retreat rule. Some states require that that you must retreat before using deadly force in self-defense. The majority uses the Model Penal Code, which does not require a retreat. Common law does not require to retreat if you cannot completely do so in complete safety. The castle exception, or if defending against an inherently dangerous felony. Miscellaneous defenses: necessity, duress, and entrapment. Necessity is when needed to sacrifice one to save multiple human lives, the choice of evils. At common law, it is not a defense to murder. Duress. Under duress, if the defendant was forced to commit a crime that is not murder, under an immediate threat or immediate death or serious bodily injury, he has a valid claim to the defense. Entrapment. The defense of unfair temptation. The government unfairly tempted the defendant to commit the crime. He can claim entrapment. The defendant must show that the crime was the government's idea and the defendant was not predisposed to commit the crime.